Here at the Library and Archives, we're delighted that the International Law Commission has returned to Geneva for its 76th session, and that we can welcome the delegates and their assistants back into the library's reading rooms as they work over the next few weeks. In this episode, recorded in August 2024, after the last session of the ILC, I spoke with Huw Llewellyn, now the former director of the Codification Division and previous secretary to the ILC. Hello and welcome. You're listening to The Next Page, the podcast of the Library and Archives dedicated to advancing the conversation on multilateralism. I'm Amy Smith, and today, as you know, the library has a very impressive legal collection. We served the International Law Commission during its annual sessions here in Geneva. And we thought that you, our listeners, would be very interested to have an interview of the progressive development of international law. And so online with me today is Huw Llewellyn, who is the director of the Codification Division of the United Nations Office of Legal Affairs. Huw also acts as secretary of the International Law Commission and as secretary of the United Nations Sixth Committee, which is concerned with legal questions. So Huw, you kindly accepted to give a talk about the evolution of international law on the podcast. Would you like to introduce yourself and tell us how you first became interested in international law and why you find it important?
Yes, Amy, thank you. First of all, for inviting me. This podcast series is an important step in helping to make international law more accessible to a wider audience, including non-lawyers, so I'm very happy to contribute. As you say, I'm the director of the Codification Division, which is one of the divisions of the UN Office of Legal Affairs in New York. And in this role, I'm also the secretary of the Sixth Committee, the legal committee of the UN General Assembly, which meets in New York, and also the secretary of the UN International Law Commission, which meets during the spring and summer at the Palais des Nations, where you're sitting now, the UN office in Geneva. So winding the clock back about 42 years, it's a long time, I began my career working for law firms in London in the early 1980s. But I had always really been interested in international affairs, travel, languages. And so when the opportunity came up, I applied to join the United Kingdom Foreign and Commonwealth Office as a lawyer diplomat, which I did in 1988, and spent close to 20 years working for that office, including being posted to the UK permanent mission to the UN in Geneva in the mid-1990s, and 10 years later to the UK permanent mission to the UN in New York. Throughout this time, I really enjoyed multilateral work, in particular negotiating international conventions, international treaties in various UN fora on behalf of the UK. But I also developed a strong wish to cross the divide, to make the leap, if you like, to working on behalf of the international community. And so I did so. From 2007, I joined the UN Office of Legal Affairs, where I've been ever since. I spent the first 6 or 7 years working on international criminal tribunals issues. And now the last 11 years, I think it is, since 2013, working on the progressive development of international law and its codification.
It does sound like you need to be interested in so many things when you're involved in law.
It's true, for sure. And you asked me, Amy, also about the importance of international law. So all of these experiences that I've just described really cemented for me the importance of international law, not just as a means of dispute settlement in courts and tribunals, but what I'll do actually is to use a quote from Dame Rosalind Higgins from 1996. She's a former judge of the International Court of Justice. So she said, without law at the domestic level, cars cannot safely travel on the roads, purchases cannot be made, personal safety cannot be secured, and without international law, safe aviation cannot take place, resources cannot be allocated, and people cannot live safely in foreign lands. Now, what Dame Rosalind meant with that quote, I think, is that international law is not only about settling disputes in courts and tribunals, it's also about ordinary everyday dealings, ordinary everyday things at the international level take place on the basis of international law. So it is the basis upon which governments interact with each other in all of their dealings, including, of course, within the United Nations. It's the basis upon which the United Nations pursues its essential mandates of maintaining international peace and security, promoting human rights, and encouraging sustainable development. And it is, last but not least, also the basis upon which international courts and tribunals are able to settle disputes among states, protect the human rights of individuals, and ensure accountability for serious international crimes. So I think for all of these reasons, Amy, it's clear that international law is an important body of law.
Very important, yes. So perhaps we can start a bit with situating 3 of the UN entities dealing with issues related to international law and see where they stand in the UN system. So these would be the International Law Commission, the Sixth Committee, and the International Court of Justice. Maybe leaving the Court of Justice aside for the moment, would you please explain perhaps what the ILC and the Sixth Committee are and how they fit in the UN system? Broadly, what do they do?
Certainly. So in a nutshell, the Sixth Committee, as we've discussed, the legal committee of the UN General Assembly and the International Law Commission work together as a kind of partnership to carry out the function laid down in Article 13 of the UN Charter. This is paragraph 1A. And that function is to promote the progressive development of international law and its codification. So the Sixth Committee is the legal committee of the Assembly. It consists of the lawyers representing all 193 UN member states. The International Law Commission, by contrast, is a subsidiary organ of the General Assembly, consisting of 34 independent experts in international law, established to assist the Sixth Committee in carrying out its responsibility under Article 13. So the origin of this arrangement is that the Sixth Committee in 1946, during its first session, decided to establish a committee to advise it on how to fulfill this responsibility under Article 13, which it duly did, the Committee on the Progressive Development of International Law and its codification, known as the Committee of 17. This committee met for a couple of months, May and June, I think, in 1947, and recommended the establishment of the International Law Commission as an independent body of legal experts, and also set out a recommended statute for the Commission. The Assembly later that year, November 1947, then adopted in a resolution the statute and established the Commission. So the Commission has existed since 1947. Its first members were elected in 1948, and it held its first session in 1949. So if we do the mathematics, we know that it's now in its 75th year. It's the 75th anniversary of the Commission meeting. The important aspect of the partnership between these two bodies is the annual interaction between them. The Commission meets in Geneva, as you know, for around 10 to 12 weeks in the spring and summer, and adopts a very detailed annual report on its work. And then the Sixth Committee in late October, early November in New York each year considers that report. It goes through it in great detail. It gives input on the Commission's work, and it gives its views on the Commission's finalized outputs. So it is this institutionalized interaction between the two legal bodies, independent experts meeting in Geneva, legal experts representing states in New York. This is the essential characteristic that enables the codification of international law and its progressive development to take place in a manner that is closely based on the practice and views of states.
Thank you. We'll get back to codification and progressive development in a moment. But also let's talk about the International Court of Justice. What's the relationship then between the ILC and the ICJ?
There is no formal relationship between the two, nor do they have the same functions. But there are, of course, important interactions and cross-fertilization between these two very important bodies, which I'll come to in a moment. But first of all, some of the differences. The ICJ is a principal organ of the UN and, of course, a judicial body. Its function is to settle disputes between states concerning questions of international law that are submitted to it, and also to give advisory opinions on questions of international law when requested to do so by other organs within the UN system, notably the UN General Assembly. So the function of the ICJ is judicial, to interpret and apply existing international law to disputes and to questions submitted to it. The ILC, by contrast, is involved in the international law making process. It was established, as we've just discussed, as a subsidiary organ of the Assembly to assist in the process of identifying and making proposals for the codification and development of international law. So really as an early stage of the international law making process. So in these terms, the ILC's role takes place at a much earlier stage of the legal process before the law has crystallized or formed. The ICJ's role takes place later, after the law has formed, and is focused on interpreting and applying the rules of international law. On the other hand, there are certainly important interactions between the two, and I mean this in two senses. First of all, in the more formal sense, the president of the ICJ visits the ILC during its session each year, and they have an interactive exchange of views on their respective bodies of work. But secondly, in the more substantive sense, the two bodies refer frequently to each other's work when carrying out their own functions. And so the ILC often refers to ICJ judgments and advisory opinions when analyzing the current state of international law and the direction in which it may be developing. And similarly, the ICJ very often refers to the work of the ILC for the same purposes, particularly because the ILC relies extensively on the practice of states. The ILC's work is thoroughly researched. Often it gives a very strong and reliable source of information that the ICJ can refer to when it needs to assess the practice of states. And then a third factor worth mentioning, although this is more anecdotal rather than substantive, of course, quite a few of the judges of the ICJ are themselves former members of the ILC. And it's quite common for ILC members to be nominated and elected by the General Assembly as judges of the ICJ. And so there's a natural affinity, if you like, a mutual respect between these two bodies. For that reason, I think that's what I would say about the relationship between these two.
It's more extensive than I imagined at first. Yes. So I also wondered how the ILC relates to other bodies within the multilateral system. I mean, those specifically working in specific areas in international law, such as human rights, humanitarian and international trade law. What could you tell us about that?
Yes, this is a good question, Amy. So again, there is no formal or institutional link between the ILC and these other important bodies that you mention in the multilateral system. But there nevertheless is a definitely common ground that they work in. So the ILC has tended to be more of a generalist body in the sense of working primarily on topics that form the overarching infrastructure of international law, its basic building blocks, its secondary rules, these kinds of things. Examples would be the law of treaties and the law of international responsibility. The other bodies that you mention work in more specialized branches of international law, human rights, humanitarian law, trade law. These branches of international law have their own institutional structures, negotiating fora, courts, tribunals, and other dispute settlement bodies. But nevertheless, the underpinning common ground among all of these bodies is international law. And on this basis, they inevitably take account of each other's work. So a couple of examples, perhaps. The UN human rights treaty bodies that were established under the various UN international human rights treaties certainly take account of the rules of treaty interpretation that were codified by the Commission in the 1960s when they interpret the international human rights treaties that they are mandated to apply and monitor. So too with the World Trade Organization, its dispute settlement bodies naturally take account of the established rules of treaty interpretation as codified by the International Law Commission. And vice versa, the Commission certainly takes account of the case law of the various international courts, tribunals, and other dispute settlement bodies around the UN system in its work. A particular example of this from 2018, when the Commission was working on a topic to do with the interpretation of treaties, subsequent practice in the interpretation of treaties. The ILC certainly took account of the work of the human rights treaty bodies at that time and had informal interactions with them, meeting face to face in order to get a good understanding of how the human rights treaty bodies looked at the practice of states on the basis of these various international human rights instruments. Similarly, the ILC's work frequently involves aspects of international humanitarian law, and these are discussed. There's an annual meeting, an informal meeting between the members of the ILC and officials of the International Committee of the Red Cross every year during the ILC session. So certainly a lot of interaction between these various bodies. International law is the common foundation upon which each of them works within the multilateral system, and is the means for exchanges of views and the finding of coherent and harmonious approaches across different specialities within the UN system.
So it is also quite vast. And I thought we could go back in time and look a little at the history of international law, if you're willing. Obviously, we can go back all the way to antiquity, but it's perhaps really around the mid-17th century. It's the beginning of the international legal order of nation-states that things start to change more. Would you perhaps give us an overview of early developments in international law following the Peace of Westphalia in 1648 and up until World War I?
Yes, Amy, you're right. This is really, as you say, the beginning of the system of state sovereignty. So people often refer to the Westphalian system of state sovereignty, also known as Westphalian sovereignty. This is a historical reference to the two peace treaties of 1648 that ended the 80 Years' War and the 30 Years' War, which were essentially religious wars involving variously the Habsburg Empire, Spain, the Netherlands, France, Sweden, the Holy Roman Empire, and an estimated 8 million people died during these wars. So what developed following the conclusion of the two peace treaties in 1648 was a move away from the notion of empires and city-states as subjects of international relations, and a recognition of countries, or states as we refer to them in international law terms, states as the basic building block of international relations, with states, however large or small, having an equal right to sovereignty over their territory. Influential in the thinking underlying this process of change were prominent jurists of that time, political thinkers of the 17th century. So, for example, Jean Bodin, a French jurist, and Hugo Grotius, the well-known Dutch jurist of that time. During the following century, the 1700s, this principle of the sovereign equality of states developed further towards a principle of non-intervention. That's non-intervention by states in matters that are essentially within the domestic jurisdiction of any other state. And this principle, of course, still underlies the modern international system of sovereign states, and is enshrined in the Charter of the United Nations, Article 2 of the Charter, setting out various principles upon which the UN is based. So moving then to the historical developments in the period leading up to World War I, before the League of Nations was established. In the late 1700s, Jeremy Bentham, who was a British jurist and social reformer, is reputed to have coined the phrase international law for the first time. He proposed an international code to regulate relations among nations, designed to provide for everlasting peace. Now, this code was based rather on utopian ideals and didn't really gain much support, but nevertheless, that code and his ideas are often referred to as the beginning of the codification movement. This is the name given to attempts to place international relations on the firm footing of written international law, to remove the uncertainties of customary international law. Customary international law is unwritten law that develops through the practice of states. So, turning to what states were doing during this early period of the development of international law, we see during the early 1800s occasional congresses, or summit meetings, if you like, between governments, held between the major European powers of that time, to develop aspects of international law. The first such congress to develop international law of a general interest was the Congress of Vienna. This is 1814 to 1815, which took place following the downfall of the French Emperor Napoleon various instruments relating to international rivers, the abolition of the slave trade, the rank of diplomatic agents, for example, were adopted by this Congress. Winding the clock forward then through the 1800s and to the end of that century and into the early 1900s, there were apparently more than 100 conferences among states during this period for the purpose of negotiating various international legal instruments. And apparently 250 or so such instruments were concluded during this time. For example, on the protection of intellectual and industrial property, the regulation of postal services and telecommunications, and the regulation of maritime navigation and aviation. Notable examples from this early period include the 1864 Geneva Red Cross Convention for the protection of the wounded on the battlefield, and the establishment of the Universal Postal Union in 1874. So this period during the 1800s was really the period when we see sustained efforts by governments to develop international law by means of multilateral conventions. We should also, while talking about the work of states, of governments, we should also mention the important work of two private codification bodies, the Institut de Droit International and the International Law Association, both established in 1873. They did and still do important scholarly work that helps to guide some of the codification efforts by governments. Coming to the end of this century, 1899, and into the following century, 1907, we see the two Hague Peace Conferences, which drew upon the earlier work that I've been mentioning during the 1800s and resulted in a significant number of conventions, in particular regulating the means and methods of war, and relating to the peaceful settlement of disputes, including the establishment of the Permanent Court of Arbitration in 1899, which is the oldest standing international court for the peaceful settlement of disputes. So very important conferences, 1899, 1907, for the development of international law. The third Hague Peace Conference was in preparation when the First World War broke out in 1914. So that brings us up to the First World War.
Yes, and to the establishment of the League of Nations. Would you perhaps then tell us a bit more about the impetus that the creation of that first global international organization brought to the development of international law following that?
Yes, certainly, Amy. As you say, the establishment of the League of Nations gave an important institutional impetus to the development of international law. The Covenant of the League of Nations was concluded in 1919 as part of the Treaty of Versailles, which brought the First World War to an end, and it became effective with the rest of that treaty in January 1920. So the League was the first organization to have as its main purpose the maintenance of international peace, which was to be achieved through collective security, disarmament, and the settling of international disputes through negotiation and arbitration, so by peaceful means. The first significant development, I think, for international law during this period was the appointment by the Assembly of the League in 1920 of an advisory committee of jurists. This was the advisory committee which drafted the Statute of the Permanent Court of International Justice, the PCIJ, which began functioning in 1922. It's, of course, the predecessor to the current day International Court of Justice. The PCIJ was the first international court with general jurisdiction over international law, and its judgments and advisory opinions made possible the clarification and development of a number of aspects of international law, which was still at a relatively early stage of development at that time in the 1920s. Moving forward just a few years, in 1924, intergovernmental efforts to promote the codification and development of international law were further strengthened when the Assembly of the League created a standing organ called the Committee of Experts for the Progressive Codification of International Law. This was composed of 17 individuals with expertise in international law, and collectively they represented the main forms of civilization and the principal legal systems of the world. That's a phrase taken from the decision which established them. This committee's function was to prepare a list of subjects, the regulation of which by international agreement was desirable and realizable, and to suggest the procedures to be followed in preparing international conferences for this purpose. So what we see here with the Committee of 17 is a preparatory role. The role of the committee was not itself to draft conventions, but rather to make the preparations, to identify topics, etc., and to make the preparations for governments to negotiate international conventions. It was on this basis, on the basis of the work of the committee, that the Assembly of the League convened the 1930 Hague Codification Conference. This was a diplomatic conference to codify three topics in particular, relating to nationality, territorial waters, and the responsibility of states for damage done in their territory to the person or property of foreigners. This was a significant development because it was the first attempt to codify and develop whole fields of international law. The conference, unfortunately, was only partially successful. It adopted international instruments on the topic of nationality, but made very limited progress on territorial waters and none at all on state responsibility. So not the most successful conference, but nevertheless important symbolically as being, and it's often referred to as, an important milestone on the road to organized and systematic codification. No further such codification conferences were convened by the League after 1930, but it did adopt a significant resolution in 1931 following the Hague Conference concerning the importance of the input of governments into the codification process. And this underlying theme is, of course, very important and central to the work of the International Law Commission and its relationship with the Sixth Committee, which we discussed at the beginning of this conversation. As we know, the onset of the Second World War caused the League to become less effective from around 1938 until it was dissolved in 1947. But nevertheless, the League of Nations represented an important first international organization established to promote collective peace and security, including through the codification of international law and promoting the peaceful settlement of disputes among states on that basis. So institutionally, a very important impetus and something of a blueprint for the United Nations, which followed the Second World War.
Absolutely. And it's fascinating. You also mentioned the Permanent Court of International Justice at the time of the League. And I was quite interested. Recently, we had a visit to the library and archives by the president of the current ICJ, Nawaz Salam. And our archivists displayed many items from the time of the League of Nations relating to international law and the Permanent Court of International Justice. And I was quite struck, because we had been talking about codification and so on, by a speech that they had selected and was there, that was written by and given by Hjalmar Hammarskjöld. His name, no doubt, people will recognize because he was, in fact, the father of Dag Hammarskjöld, the famous former UN Secretary General, and also Åke Hammarskjöld, who was part of the League Secretariat, and he worked on the statute of the Permanent Court of International Justice, and he became the registrar of the court and was later also appointed a judge. But going back to their father, Hjalmar, he was the chair of the Committee of Experts for the Progressive Codification of International Law, and his speech caught my eye because he said, I'm reading this, "We all know that international law, which aims at assuring justice by giving each his due, sum cuique, and by asserting the principle neminem ledere, does not presuppose, as an imperious and absolute necessity, the existence of formal written text. On the other hand, codification is plainly of the greatest value for assuring certainty and clearness in the law." And I think you've spoken to that already about what is codification and progressive development. But perhaps you could just clarify a little bit more exactly what those two terms mean.
Yes, thank you again, Amy. Very important terms. And the definitions, if you like, of these two terms are contained in the statute of the International Law Commission. But I'll come to that in a moment. These two terms, of course, first get mentioned in Article 13, that we've been discussing already, Article 13 of the UN Charter. where the role of the Assembly is to initiate studies and make recommendations for the purpose of encouraging the progressive development of international law and its codification. The International Law Commission, established in 1947, its role is to assist the Assembly in carrying out that function. So turning to Article 15 of the International Law Commission Statute, the definitions are a little bit technical. I'll read both of them, but then I will try to give my own potted version of what I think they mean as well. Codification, according to the statute, is the more precise formulation and systematization of rules of international law in fields where there already has been extensive state practice, precedent, and doctrine. So that's codification. Progressive development, by contrast, is the preparation of draft conventions on subjects that have not yet been regulated by international law, or in relation to which the law has not yet been sufficiently developed in the practice of states. So in my mind, codification really refers to identifying and writing down existing law. The Commission, the International Law Commission, is working to identify and write down in clear terms existing international law that has been developed through extensive state practice. Primarily, of course, this refers to customary international law. And the purpose is to make it more accessible and more precise as a good basis for international relations. Progressive development are really legal policy proposals. So the Commission, when it's working in the area of progressive development, is going further than the existing law. But, and this is very important, it's nevertheless still building on existing state practice. So it's looking at state practice that has not yet developed into customary international law, and it's making policy proposals where the law could develop for the future, progressive development. Having said all of this, the Commission has made it clear since the outset, when it started working in 1949, that it regards a clear distinction between these two notions as unworkable. That's the word that the Commission used, unworkable. In practice, all of its products are, in fact, a mixture of these two things. And there's a good quote, which I will read briefly, by Alain Pellet, who is a former Commission member, which sums up the reason underlying the difficulty of the Commission in distinguishing between these two terms. So Alain Pellet said, all topics involve partial codification, since no topic is entirely new when it is undertaken by the Commission. In addition, all topics imply an element of progressive development, since, almost as a matter of definition, customary rules always comprise some elements of uncertainty, calling for clarification. And this is precisely one of the main purposes of codification. So, in a nutshell, codification and progressive development are part of a spectrum of activities that the International Law Commission undertakes. It's always dealing in one way or another with both of these things in all of its topics. I hope that helps.
It does, and it's very interesting, I do think. Yeah.
Good.
I also noticed that you've spoken already that the ILC has had its 75th anniversary, but at its 70th anniversary 5 years ago, there was a publication called Drawing a Balance for the Future that came out at the time. And in the Secretariat's introduction to that, there was an argument put forward that knowing what international law is and the direction in which it's developing is really fundamental, since international law is the framework, the substance, and the vocabulary of international discourse. I think you brought that out in your introduction today when you spoke about the importance of international law. But I'd like you to say perhaps a bit more about how stability and change in international relations is reflected in the work of the ILC.
Mm-hmm. Thank you, Amy. Yes, I remember working on that introduction to the 70th anniversary publication. We put a lot of work into that, and I'm happy that you've referred to it today. My own view is that the ILC has actually been remarkably successful over the decades at continuing to work in a scientific, legal way on its topics, whatever the state of geopolitical relations or tensions outside the Commission. It has generally not reflected broader political instability in difficult times, such as those that we face now. Even in these challenging times, international law remains, and it's, as you just said, Amy, the essential vocabulary that states use in their everyday dealings with each other, and it's the glue, if you like, in their relationship. Moreover, even in situations of accusation, rebuttal, contestation among states within international fora, within the United Nations, for example, international law still remains the language of these exchanges. So international law is important across the board for all of these reasons. Knowing what international law is and in which direction it is developing are fundamental to encouraging stable relations among states. And in terms of the ILC's work, achieving a balance, therefore, between codification of existing international law, writing it down in a clear and accessible fashion, and incremental development of the law, developing it in a way which is still firmly rooted in the practice of states, may be the best means, I think, that the Commission has of promoting stable international relations. Interestingly, these matters, this is another historical reference, these matters were discussed right from the outset in the preparatory meetings drafting the Charter of the UN in 1944 at Dumbarton Oaks. What is apparent from the record of the discussions on Article 13, paragraph 1A of what became Article 13 of the UN Charter, using the terms codification and progressive development, these were considered during the negotiations to strike a good balance between stability of international law as the foundation for international relations and development of international law in a progressive, meaning an incremental manner, so that the law neither stagnates but nor does it leap ahead in unforeseeable ways. And so this is really the thinking underlying Article 13. And we see this reflected as well in the working methods of the International Law Commission, which relies very heavily on the practices of states and takes account of the views of states, which are fed in on all of its topics annually during the debate in the Sixth Committee that we've discussed already. The Commission has throughout taken the view that codification and progressive development are difficult to dissociate and lie on the same spectrum of activity. But to answer perhaps more directly your first question, I think that the balance between codification and progressive development in the work of the Commission reflects more the dynamics within the Commission and the length of time that it's been working, rather than geopolitics outside the Commission. The Cold War decades, the 1960s, 1970s, were very productive ones for the Commission, when much of the foundational architecture of international law was proposed by the Commission and concluded by states. It's really the fact that the Commission has completed much of that codification work from earlier decades and is now in different territory that explains some of the change in its outputs.
Right, yes, so exactly. I was going to ask you about the outputs and how you think that this has changed over time.
Yes, the Commission's topic choices and the forms of its output have certainly changed over time. And in some circumstances, this has had an impact on the extent to which the Commission is codifying on the one hand or progressively developing international law on the other. The primary reason for this change, as I just mentioned, is that much of the foundational architecture of international law, the law of treaties, diplomatic and consular relations, the law of the sea, international environmental law, international criminal law, many of these projects have been completed or mainly completed by the Commission in earlier decades, which means that the Commission now has had to move to some extent into newer and more specialized areas of international law that may be less settled. And consequently, the balance between codification and progressive development has moved perhaps a little in the direction of progressive development. Examples of these types of newer or more specialized topics would include the current very important one being dealt with, sea level rise in relation to international law, piracy and armed robbery at sea, which is on the current program of work, protection of the atmosphere, which was completed a few years ago, and protection of the environment in armed conflict, all fairly specialized niche areas of international law. A further significant factor affecting the Commission's outputs has been the reluctance of the Sixth Committee for the last 20 years or so to decide that any of the Commission's products should be negotiated into treaties. So the last treaty negotiated on the basis of the Commission's work was concluded in 2004, exactly 20 years ago. The reasons underlying this reluctance are not entirely clear, but probably relate to the broader overall downturn in the conclusion of multilateral treaties among states. There seems to be a degree of treaty fatigue. States more and more use less formal cooperative arrangements and non-legally binding international instruments. So arguably in response to this, possibly in response to this, the Commission has produced an increasing number of products that are not in a form intended for negotiation by states into treaties, such as conclusions, guidelines, principles. These have become fairly common outputs of the Commission over the last decade or more. It's important to emphasize, however, that these new forms of Commission products can be equally valuable for states in clarifying what international law is and how it might usefully develop. So against the background of these changes, the types of product that the Commission produces, and this is my own personal way of thinking about it, fall into the three main types. First of all, what you might call unfinished business. I'll come back and explain that in a moment. Unfinished business, more classical topics, and then new, more specialized topics. So unfinished business. This has a more technical name. Some people refer to it as complementary or annotative codification. But what it really refers to is updating or building upon some of the foundational or architectural codification work. Examples would include the Commission's conclusions on subsequent agreements and subsequent practice in the interpretation of treaties from 2018, or its guide to provisional application of treaties, which it completed in 2022. Both of those topics take aspects of the Vienna Convention on the Law of Treaties, 1969, which were unfinished or not fully developed in 1969, and it puts more meat on the bones, if you like. So the Commission has worked on this type of codification quite a number of times over the last 15, 20 years or so, I would say, unfinished business. The second type of product, then, coming back to classical, there are still some topics that the Commission has not had the opportunity, or did not have in previous decades, the opportunity to complete. These really focus on the sources of international law. So it's quite recently, 2018, that the Commission finished its work on customary international law. One of the main sources of international law referred to in Article 38 of the ICJ statute, and also general principles of law, which is still under consideration by the Commission and should be finished next year, 2025. Again, a set of draft conclusions on that topic. This is one of the sources of international law referred to in Article 38(1) of the ICJ statute. These are really methodological topics. They focus on how to identify customary international law and general principles of law. So these I've headed under classical outputs. And then we come to the third area, new and more specialized areas of international law. There are inevitably a limited number of classical topics left. And so the Commission is moving into these more specialized, but very topical and very important areas for states. For example, as I just mentioned, sea level rise in relation to international law. This has huge interest among states in the General Assembly. A lot of support for the Commission taking on this topic. So these new specialized areas of products by the Commission, I should emphasize, they still have a strong basis in existing international law and are very much based in the practice of states. This is the theme always with the International Law Commission. All of its work is really based in the practice of states. I hope that wasn't too long, Amy.
No, not at all. It really is very interesting and so important. I think if you were going to perhaps highlight one or two main achievements of the ILC, what would you choose?
That's a good question. I think, well, first of all, you would have to go back, I would have to go back to the foundational infrastructure of international law produced in those early decades of its work. And when we were speaking historically before and during the period of the League of Nations, this foundational infrastructure of international law was not in place. So this has to be one of the major achievements of the Commission. And I'm really referring here to the law of treaties, the law of state responsibility, the law of responsibility of international organizations, important aspects of environmental law, international criminal law, the work which was the basis for the later negotiation of the Rome Statute of the International Criminal Court. All of these things are huge achievements of the Commission. If I had to choose one of the current topics, I would say it's work on sea level rise, because this really is addressing something which is of critical importance to the international community, not just to the Pacific Island states who are suffering the most from that phenomenon, but this has now gained huge support in the General Assembly. So if I were to single out some topics, it would be those. Perhaps its other main achievement is to stay relevant in this way, even at its 75th anniversary.
That's always very good. And to end on sea level rise is also very pertinent, because we hope to have at least one of the members from the Commission, invite them to a podcast to be able to talk a little bit more about that and other environmental issues. Finally, Huw, you will be retiring from office soon. And thank you very much for your introduction to this topic. It was very in-depth and very enlightening. Perhaps on a little lighter note, could you give us a book suggestion?
It's very well timed, because I think I have 7 working days left as a UN staff member. I retire at the end of September, so it's a week and a half away, something like this. So your question is a very timely one. Reading, I certainly enjoy. I have to confess that I like rather light reading. So my book choices are really fiction choices. I'm very much into the murder mystery, crime thriller variety of books. 2 authors I would recommend strongly to your listeners: Lee Child and Martin Walker. These are both British authors. They've written excellent series of the crime thriller, murder mystery kind of book. There are about 15 to 20 books in each series. My own intention, because I've read them all, I have to say I've read all of these books already, so I don't have any left to read. But my own intention is to start rereading them now in French, partly for enjoyment, but also just to improve my French. I really need to make some advances with my French, and that's an enjoyable way to do it. Languages, as I mentioned at the beginning, is really one of my great interests. My main challenge at the moment is to get my Swiss German off the ground. My wife is Swiss German. I really have to improve. And then finally, as I'm retiring, I will be able to spend some more time in the place that I come from, Wales, my own country. I've lived much of my adult life not in Wales, and my Welsh has suffered. So I really need to take my limited Welsh, dust it off, and improve it again whilst at home. So those are my intentions for retirement.
Those sound magnificent projects. Huw, thank you very much for joining us today.
It's been a real pleasure, Amy. Thank you for inviting me to the podcast.